Taxpayers must benefit from stem cell research. If you pay somebody to build a house, you expect a profit when it's finished. Probably you will live in it, perhaps you will rent it or sell it for a profit. Similarly, when you pay a biotech company to develop drugs and cures through stem cell research, you expect a direct benefit. At a minimum, you deserve affordable access to resultant drugs and therapies. Proposition 71, passed by the voters in November 2004, takes $6 billion of California taxpayers' money, yours and mine, to fund bonds providing $3 billion for stem cell research. Prop 71 promises public benefit, but whether that actually comes about will depend on the details of who controls the discoveries and how technologies and treatments developed from those discoveries are priced. Those details, known as intellectual property policies, are not spelled out in Proposition 71. On Wednesday, an Institute committee will begin developing the IP rules for how Prop 71 money is granted to biotech corporations. Your eyes probably glaze over at intellectual property, but it's time to wake up and pay attention. The policies will determine whether new life-saving drugs will be affordable to the taxpayers who are financing their development. About half of California's families are estimated to have a member who could potentially benefit from stem cell therapies. Most of the media fuss surrounding stem cell research has been over political and social issues surrounding the use of fertilized human eggs. But it's the boring, really technical IP regulations that could mean whether or not you will get treatment someday. The biotech industry is lining up to take Prop 71 money and wants as few strings as possible attached. Speaking to biotech executives at a conference his firm organized in San Francisco, Steve Burrell, chairman of the venture capital and merchant banking firm Burrell & Company, described the capital funding being provided by taxpayers in California and a few other states as, quote, almost like free money, unquote, compared to commercial venture capital. The phrase is a tip-off to the lack of any sense of obligation. Clearly defined IP rules governing such things as price and accessibility by underserved populations will ensure that businesses meet fair obligations to the public when they take the public's, quote, free money, unquote. The state's Independent Citizens Oversight Committee, appointed by various constitutional officers to oversee Prop 71, has already proposed intellectual property rules for universities and nonprofits. They're a good first step, though needing improvement. They require a modest financial return to the state on profitable discoveries. They do not do enough, however, to ensure that all Californians will have affordable access to the fruits of the taxpayer-funded research. They do provide a minimum starting point for developing rules for private biotech companies. The university and nonprofit regulations demonstrate a laudable concern for the needs of poor and uninsured, but all Californians are paying for Proposition 71, and all should benefit. It's imperative that the California Institute of Regenerative Medicine's IP rules be based on three principles: affordability, accessibility, and accountability. The committee has not ensured that drugs or therapies would be sold at an affordable price for all Californians. Certainly, drug firms are entitled to fair profits. They just aren't entitled to charge exorbitant rates for their products when taxpayers directly funded the research that made a drug possible in the first place. It's essential that the State Attorney General has the right to intervene in cases of unreasonable pricing of Prop 71 funded drugs or cures. What's unreasonable could be determined through a public process. There is still time to fix the university and nonprofit rules as well. The Oversight Committee will soon open a period of public comment on the plan just adopted. In writing IP rules for business, the Oversight Committee must remember that Californians never intended to write a blank check for biotech. If a patentable discovery results from Prop 71 funded research by a business, the state should own it through a patent pool. Rights to profitably commercialize the discovery could be licensed back to the firm. If Prop 71 funds research, perhaps a clinical trial for a treatment already covered by a patent owned by a business, California should receive a fair commission. The state should be able to take cash payments or, like any venture capitalist, negotiate an equity share, that is stock, in the business. The results of taxpayer-funded stem cell research could save your or a loved one's life. Don't let your eyes glaze over. Intellectual property rules based on affordability, accessibility, and accountability will keep Proposition 71's promise to all of California's voters.
This is Mark Strassman, reporter with Etopia Media's California Politics Today. We're about to speak to John M. Simpson, who's the Stem Cell Project Director at the Foundation for Taxpayer and Consumer Rights in Santa Monica, California. Welcome to California Politics Today.
Thank you.
Tell us a little bit about the FTCR, the Foundation for Taxpayer and Consumer Rights. What is it? What does it do?
Well, we're a foundation that serves in the public interest. We're California's biggest best-known non-profit, nonpartisan consumer advocacy organization.
And where does the stem cell issue generally and the spending of Prop 71 money and the return on it fit into the context of your philosophy and activities?
Well, we had no position on Prop 71 when it was before the voters, but once it was passed, we felt that it was important because there is essentially $6 billion of taxpayer money at stake, that we monitor the implementation of Prop 71 and make sure that it is implemented in a way that serves the public interest.
Okay. From what you said, I may know the answer to this, but I just wanted to cover 2 points here. There are some objectors to Prop 71 on the grounds that using fertilized human eggs violates the sanctity of life. Is that an issue that you address, or it's outside of your purview?
That's really outside of our purview. We really think that the voters passed it overwhelmingly, and what we're concerned about is making sure that it is implemented in a way that the promises of public benefit that were made at the time that the issue was on the ballot, that those are fulfilled.
Okay. There's also an objection, and in fact it's taken the form of a lawsuit that's prevented the raising of any of the money so far,
right,
on the grounds that the structure of Prop 71 that it's set up violates Article 16, Section 3 of the California Constitution, requiring public funds to be spent by organizations under the exclusive management and control of the state of California. Does the foundation have a position on that and on the lawsuit?
We think that the way it was set up, that there were a number of conflicts built into the law that are not very good public policy, and we're working to try and make sure that those built-in conflicts get corrected, and that the Institute does the public's business in public, and that there is transparency about everything that they do.
Okay, let's pull back a little bit to the campaign that passed Prop 71 and the promises that and the support that biotech companies provided for that campaign. How would you summarize what the biotech corporate position was on Prop 71, and what kind of representations did they make to the public in order to facilitate its passage?
I think there were a lot of promises made about the possibility of very quick cures and very quick payback, and there were specific suggestions about royalties that the state could get back, estimates up to $1 billion.
Right.
And interestingly enough, once it was passed, people started to be saying things like, well, gee, maybe the state shouldn't get a share of those royalties. One of the things that we were very involved in was the intellectual property policy that was developed for the not-profit organizations, research institutions, and universities. And we insisted that there be, as was provided, we felt, in the original proposition, some direct payback to the state. And that through our efforts and the efforts of some other folks, some in the legislature, did get added into that IP policy for the nonprofits, which is that 25% of any royalties would come back to the state once the threshold of $500,000 is is crossed.
Well, are you aware of the California Council on Science and Technology report that addressed all this? Who are they, and who makes them up, and what do they have to say about this?
They're represented by a number of people. And they had a task force that looked at developing both stem cell policy and a broader intellectual policy for the state. They had a working group that had a number of people from the biotech industry, from academia, that sort of thing. Their recommendation was that there be no return to the state. Although they then did go on and say, but if you do decide to go that route, then had some suggestions. But essentially was that there should not be a payback to the state.
Do you think of the situation, or do you characterize it publicly as a bait and switch?
I think that there have been aspects of Prop 71 where that term would be appropriately applied.
Okay. Could you bring our listeners up to date on the procedural situation and the process, and the ICOC, which is pretty much in charge of doing this for itself, what kind of hearings and proceedings are going on there, and where things stand in terms of the formulation of the policies that you're interested in?
The ICOC is the so-called Independent Citizens Oversight Committee.
Just as a note, what is it independent of?
That I'm not sure of. That's what they call it. That's what the proposition referred to it as.
Right.
And one of the things I think that is troubling about that whole process is the way the committee is constituted. It essentially is made up of representatives of academia who are the the very institutions that will be getting the grants, some biotech representatives, life science representatives who are obviously tight with the industry, and then 10 patient advocates, all who have a specific axe to grind. I'm sure with the best of motives, but still they're, for instance, very interested in cures, one of them for juvenile diabetes, another one for Parkinson's, another one for AIDS, and so they have a specific axe to grind. So you have an oversight committee that's referred to as being independent that really is designed to have a lot of built-in conflicts. They are the essentially the board of directors of the California Institute for Regenerative Medicine, or CIRM. They meet now every other month, usually a day-long meeting. There'll be a meeting. Next one will be this Thursday, April 6th, here in Los Angeles. Initially, there was a great concern about whether they would follow appropriate open government rules. In fairness to them, I'd have to say that they have improved and done a better job of that than they did in the beginning.
But the decision as to what the rules are going to be, who's it up to?
Well, the way right now, the IP rules, for instance, they have a task force, a subcommittee that has held a number of hearings, and then the staff came up with a working document that was presented to that subcommittee and substantially altered during a working session where they did take comments from the public. That's where they added the requirement for 25% back to the state. That's where they put in a provision that any drugs or cures would be sold to publicly funded health plans at the Medicaid price, which is generally the lowest price. There was a provision inserted there that uninsured populations would have to have a plan to have a drug or a treatment available to them. That was all passed by the subcommittee. It then went to the full ICOC, who approved it in February, and it is now just about to enter what's known as the Office of Administrative Law procedure, where it is subject for 45 days of public comment, and then after that it may be tweaked slightly depending on the comment, and ultimately it then goes into the regulations go into effect with the force of law, which probably would happen sometime in the fall. That would be the IP policy for research institutions and universities. Just started last Tuesday the first hearing by the task force for IP policy for businesses.
Okay, now let's talk about what's at stake there. What are the questions that have to be resolved in the formulation of a policy?
I mean, what you're talking about there is who owns and controls the results of any discoveries that come out of money that has been provided by the taxpayers.
No, it's
money in this case to businesses, directly to biotech.
Geron, Genzyme, Amgen.
If they apply and get a grant,
those companies,
absolutely, yeah.
They're eligible and would be encouraged to apply for money from the CIRM, the CIRM, right, to do research.
Right, and the way that works is that there is a working group, the awards working group, which reviews applications and then recommends to the ICOC whether a grant should be made or not, and then the ICOC is the one that ultimately would vote yes or no.
Okay, what do you understand is the position of the biotech community on this, or is there one? Is there a trade association? Are there separate companies? Do they have spokespeople? What's their view on what they're going to do or not do?
Well, I mean, there were two folks involved in biotech. The executive vice president of Genentech was one of them, who spoke at this meeting last Tuesday. And, I mean, I like to characterize what they said essentially as this. Give us the money the way we think it should be handed out, which is with no strings, or we'll pick up our Petri dishes and go home. It was a very much the notion of this money. If you expect us to take it, give it to us. And in fact, in some venture capital circles these days, the CIRM money is being referred to as almost like free money. Now, that troubles me when we're talking about $6 billion of taxpayers' money.
Is there pretty much an expectation that there's an entitlement to this money on the part of the biotech companies?
It's difficult to put motives in someone's mind. I mean, they did seem to be. I think some of them may feel that way.
Okay.
Yes.
Now, how essential to this project, to the development of cures and treatments through research into the mechanisms of embryonic stem cells, is the participation of the private biotech sector, as you see it?
At some point in the process, it's probably necessary for commercial firms to have a role in bringing a particular product or drug to market. And this is a lengthy process because we're talking right now about upstream research that might be done at universities and at research institutions. It's not at all clear that there's a role there for public firms. As things get closer and closer to actual treatments, yes, there probably is a definite need for involvement on the part of corporations. But what's important is that while it's appropriate for those corporations to make a reasonable profit, it's not right for them to charge exorbitant fees, exorbitant profits, particularly when what got them to where they're successfully commercially was public money.
Now, you mentioned in the op-ed piece that we were including on this with this article,
right,
that one possibility would be for the state to take an equity position to get stock from the companies that do the research. Yeah. How viable an alternative do you think that is?
Well, I mean, there's different kinds of situations that apply here. I mean, one situation could be where you go to a company, you give them money, they come up with something that then deserves a patent. It's a new invention that deserves a patent.
Assuming their research pans out not at all, they won't owe the money back, will they? The question I'm trying to determine here whether there's a socialization of risk and a privatization of profit?
Well, we don't really want to see that. I mean, we think that there should be a return for the state if there is profit. Now, the thing is that there are several different ways that a firm could get money from CIRM. I mean, it's conceivable that they would get a loan.
That they'd have to pay back.
That they'd have to pay back. And the rules for that would be fairly straightforward. It's possible that they would take a grant to develop something that would then be patentable. Now, it's our position that patent should go into a patent pool that the state would control so that other firms could benefit from it. Now, the third possibility might be that they would go to CIRM seeking money to develop something that they already have a license to, or that they already have a patent on. And in that case, that's where we were suggesting that, well, there should be a commission, if it turns out to be profitable. There should be a commission back to the state. That could come as cash payments, or it could work just like it does with any other venture capitalist, which would be that the state would have an opportunity to get some equity in the business.
What seems unique about this, one of the many unique things, is that it's very much a venture capital model, except that the investors, according to these companies, have no right to participate in the benefits. Is that a new kind of ad venture capital, that the people who pay the money up front don't stand to make any benefit if there's
you mean under the model that
the biotech companies are proposing? It's kind of a
that's sort of the way it seems to me.
Heads I win,
and we're trying to say no, that can't be that way. Okay. It's the wrong way to go.
On the question of where these discoveries would be made, if they're made, they'd be made at UC Berkeley, they'd be made at US University of California, San Francisco, at Stanford, at UCLA. Or they might also be made at private biotech companies.
Right, and the rules governing discoveries that were made at the UCs and the other institutions, those are already in place.
And you're reasonably happy with that?
There's things that need to be done to improve those rules. I mean, we think there's the need to have. The way the model works is they discover something, they then license it to a private company who then uses it to come up with a drug. If that comes up with a drug that makes a profit, we think that the money needs to come back to the state, as explained, 25%. Beyond that, what the rules do not cover is there needs to be an ability to make sure that the drug company doesn't overcharge all the people in California. That's where we say the Attorney General has to be able to march in a case of unreasonable pricing.
Okay,
so those are the rules for non-profit institutions.
Right. So it now stands if someone, the Stanford Biology Department comes up with a discovery, they can license it to someone.
Right.
The profits that Stanford gets from that licensing, 25% of those would go to the state of California under existing situation. But the rules as to whether biotech companies would be similarly required is up for grabs now, hasn't been determined yet.
Exactly. Okay. That's what's being written right now.
Okay. One of the reasons I wanted to focus on the process after the technology is developed through the research money and the commercialization of it, the giving it a brand name, the putting it in packages, the writing
clinical
tests, and so on, and the making the possibly massive profits from it. Is it only private biotech companies that could do that, or since the state of California has already it's in for a dime, it's in for $6 billion already, and it's created it hopes to create an unprecedentedly large involvement of the public sector in the medical research project, wouldn't it be not much more of a step to say that there should be, say, a State of California biotech corporation that could hire a staff, become a private-public partnership, and do the commercialization with its own petri dishes, its own marketing department, and its own staff of lawyers to make that money, and that would be controlled by the state of California, and 100% of the commercialization revenues would come to the state of California. Is there any administrative reason why that couldn't be done?
I'm not a lawyer, but I mean, I think it's an intriguing concept. I suspect that some people might question the infrastructure that you would need to put it together, but it certainly seems to me that it would be an idea that would be worth discussing and exploring further.
Okay.
I mean, our point is that we need to make sure that for the $3 billion in research money that California is putting up, coupled with the $3 billion in bond financing, $6 billion of taxpayers' money at stake, that there's a fair, equitable return and a public benefit for the people of California.
Talk about the organizing that the Foundation for Taxpayer and Consumer Rights is doing to implement the policies that you'd like to see in place.
Well, we've been speaking out at all of the different meetings that they've had. We've fairly frequently talked to folks in the media like yourself to try and highlight the issues.
Has the media been covering this issue?
There is a lot of coverage of Prop 71 by papers, by the newspapers.
And have they covered the issues that you're trying to raise here about the return to the California voters for their investment?
I think that there could always be more, but I think that the issue has been raised. Is being written about. The fact that the op-ed page, the San Francisco Chronicle is the hometown newspaper of CIRM. They were delighted to run the op-ed piece that we discussed. I mean, so things are getting out there.
Let's try to focus on who's going to make these decisions and what kind of impact you and the editors of the San Francisco Chronicle or anyone else can have. Isn't the decision on what this policy is going to be absolutely and 100% under the control of the ICOC itself at this point?
Yes.
And the legislators can't do anything about it, and the governor can't do anything about it.
Well, the legislators.
What can the legislators do?
They do have a bill that they're trying to pass that would. Senator Ortiz and Senator Runner have introduced, which would try and put into law some of the things that reforms that are needed.
Doesn't Prop 71 rule that out?
Well, no. They've got it. What they do, basically, what happens is that they're trying to do it in a way that would put it back on the ballot as another proposition. So it would have to be passed by the Assembly, the Senate, signed by the governor, and then it would go on the ballot.
So absent another initiative,
it can't. The way 71 would. But there is clearly some response to public pressure, outrage. And that sort of thing. I mean, we've seen that happen, and
without making a too far-fetched analogy, all over the world, in France and other places, people who are unhappy with government policy take to the streets. And in Los Angeles, 500,000 people complained about immigration policy not 10 days ago. And I guess I'm wondering whether you think this is obviously not an issue that excites the public imagination to the extent that some of these other questions do. But I'm wondering whether you think the public can actually have an impact on these decisions as to what happens as a result of the money that they're investing and paying for this research.
The public definitely has an impact. I mean, when my article appeared in the San Francisco Chronicle, I happened to see a staffer from CIRM the next day at the meeting. She said to me, "Thanks for writing that article. You really made my life tough." I said, "What do you mean?" She said, "I got 15 or 20 emails talking about how the IP policy needs to be shaped." That sort of thing does have an impact.
What should people look for, and what can people do in the time between now and whenever a policy is determined?
Well, first thing they should be looking at our stem cell page, which is www.stemcellwatchdog.org. I'm sorry. Again, www.stemcellwatchdog.org, or our main page, which is www.consumerwatchdog.org. It's not a bad idea to follow the official proceedings on the CIRM website, which is www.cirm.ca.gov, and there will be spelled out there provisions of how people can comment once the comment period opens. We will be organizing some opportunities to make sure that people have the ability to comment directly to CERM as well.
Okay. Thank you very much for talking to us today on California Politics Today, and I hope we can check in with you again as the process continues.
I would look forward to that. Thank you.